Let's turn now to some factual distinctions between Madoff and Bayou. Let's assume that we lose in this argument about the good faith rule being wrong, and let's assume the should have known standard is applied in Madoff. Are people at risk? Well, as Jeff mentioned, there are a number of enormous distinctions between Bayou and Madoff. Jeff mentioned one or two of them. He mentioned the very important distinction that in Bayou, the people he went after were people who fully redeemed. He didn't go after the people who partially redeemed. He had reasons for doing that for not going after them that may not apply in Madoff. That is, he was able to get a result that pretty much put the victims on par with the people who had redeemed, equalized the returns to everybody. But the key point is it's going to be very hard for the trustee, Mr. Picard, to go after people who only partially redeemed. Because what does it mean that you only partially redeemed? It almost certainly means that you didn't have suspicions of fraud. Because if you had any suspicions of fraud whatsoever, you probably would pull out all your money, not just some of it. So to the extent that subjective good faith matters, to the extent it's not a completely objective test, and it could be argued that it's entirely objective, but to the extent subjective elements matter, and the Bayou judge thought they did matter, that's an extremely important distinction. Now, there are some people in Madoff who fully redeemed. Our sense of it is, and I think most people's sense, is that the number of people who fully redeemed is relatively few, that there's a huge number of people who pulled out a lot of money, may even have gotten profits, but didn't pull out everything. That's one distinction. Here's another critical distinction between Bayou and Madoff. In Bayou, as Jeff mentioned, pretty much everybody that he went after for principal had been on notice of particular facts that the court deemed red flags. For one reason or another, they had stumbled across these facts. I mean, my clients, to mention a fact that is public, were tipped off by the FBI. Now, if that's not a red flag, I don't know what is. In Madoff, I don't think you have, there may be some investors, there may be some groups of investors who did have access to particular facts. We haven't heard stories of a lot of that. It appears that most people who pulled money out, weren't on to anything remotely like that. A lot of people who pulled their money out in Madoff, either they did it with no suspicions whatsoever, or if they had suspicions, it was less a suspicion, a concrete suspicion that there's fraud, than a sense that we believe in transparency. We don't believe in investing in a black box. And Mr. Madoff isn't prepared to give us to open up the kimono and give us any details. And therefore, we're going to pull our money out. In my view, that's a great case from a defense perspective to litigate, to ask the courts, should somebody like that, who does the right thing and pulls their money out because they're not getting the full story, should they really be punished? Jeff, I don't know if you want to respond to some of those points?
I think I shall. First of all, the notion that equalization, fairness, and equity among similarly situated investors within a very similar, if not identical, time frame, that's the concept that we used in Bayou, and that's the concept that at least Phil in his argument is rejecting. And I don't know how the appeals courts are going to come out on it, but the concept that two people who invest at the same time, each invest $1 million, one decides to redeem a month later because he hears of one of these red flags, and he redeems, and 3 days later that same red flag has swirled around, and the second person with the $1 million wants to redeem, and he can't because the scheme has been found out. Everybody has tried to redeem. Those who redeemed and there was money there, they got paid, and the money ran out. Okay, so if the money runs out one day, and the day before Phil's redeemed, and the next day I try to redeem and I can't, why does he get to keep his $1 million and I get zero? Okay, it's the same. It was the same general time frame on the same fact patterns, the same information floating out in the marketplace. And what we said, and the court agreed with us, is equalization is fair. The concept of the bankruptcy statute, the concept of bankruptcy law is fairness and equity. Promote fairness and equity among similarly situated creditors and parties in interest. And that's the theory that we used. The theory Phil is advancing is not fairness, is not equity. It's first in line, first in time, and I get it and I get to keep it. That concept works in bankruptcy, but only if you're a secured creditor. And none of these investors were secured creditors and had any prior right to distributions over and above similarly situated investors. So that's the other side of the argument. As far as the concept that the word, the fraudulent conveyance statute would allow Phil's argument value, meaning the debt associated with prejudgment interest on your fraud claim. Congress knows how to use the word debt. Okay, it uses it in the statute. It doesn't use it in Section 548, and it certainly doesn't use it in the context of 548C, where it says that you're entitled to keep for value that which you redeem in good faith. Okay, and by the way, the statute doesn't say bad faith, it says lacks good faith. And I think there's a difference. And there's nothing, and the same way the statute uses fraudulent conveyance in connection with a constructive fraud, where the recipient of the transfer didn't engage in any fraud, and even in the actual fraud context, the recipient of the transfer did not engage in the fraud. Congress knows how to use the word debt, and had Congress intended for prejudgment interest on tort claims to constitute value for purposes of good faith, it could have said so, and it didn't. So, whether that ultimately is decided on appeal or not, I guess we'll see. So, those are, I guess, a couple of the comments.
First, just briefly to respond to one of Jeff's points, and this is a critical legal and policy dispute that people disagree on. Jeff's point was, the purpose of the law is to put people in an equal position. If I got my money out, if I was lucky to get my money out a day before the fraud collapsed, why should I be in a better position than you? That's really the crux of the position that the judge adopted in Bayou. The reason we think it's wrong is that rationale is the rationale that underlies the preference law. The preference laws say that if you got your debt paid within 90 days or a year if you're an insider, you have to give it back and you have to stand in line, be equalized with all the other creditors. If you got your debt repaid or received a transfer more than 90 days out, you shouldn't be in the same position. In other words, Congress decided the equalization rationale only applies if you're within the 90-day preference period. And the error, the key conceptual flaw of the Bayou court was to take the preference rationale and apply it in a case applied in a case outside the preference time periods. And that, in fact, is what the Second Circuit says in Sharp, and it's what Judge Breyer and Judge Easterbrook said in the two cases that I mentioned, that the fraudulent conveyance laws are not designed to undo preferences. If you're a creditor who gets treated preferentially, there's no remedy unless the preference occurs within the preference period.